Please be seated. Good morning. We're here for oral argument in case number 1, CACV 16-1091. Rebecca S. And take a stab. Schledorn and Eric J. Weir. Okay, sorry, a little bit tricky. Council, just a couple of preliminary things. Reminder that these proceedings are being video and audio recorded, so please identify yourselves as you approach and begin your argument, and also let us know who you're representing. Each of you will have 20 minutes. You don't necessarily need to use all that time, but you'll have 20 minutes, and Appellant's Counsel, you're responsible for watching the clock, monitoring that time to see, or if you'd like to reserve any time for rebuttal. And also, please keep in mind, we've read the briefs. We have discussed the case in conference earlier this morning. With that, Mr. Geiger, you may proceed.
Good morning, Presiding Judge, and may it please the Court. My name is Timothy Geiger, and I represent Rebecca Schledorn, the appellant in this matter. I'd like to try to reserve about 4 minutes of my time for rebuttal, if I may. Your Honors, there's 3 issues were briefed in this case. Briefly, those issues were whether it was error for the trial court to preclude appellant from testifying as to the value of the real property at issue, whether the instructions to the jury regarding gifts resulted in reversible error, and whether the court abused its discretion in awarding attorney's fees and costs to appellee Mr. Weir. Your Honors, the court's preclusion of appellant's testimony as an equitable owner regarding the value of the real property in this case was error based on the case law in Arizona. Not only do we have the owner exception to the expert requirement when a party is testifying as to value of their real or personal property, but as cited in my brief in the I believe it's pronounced Gordy opinion, and the Gordy opinion, and also I believe it's a case that may have not been cited, but there's another case, Coventry Homes versus Scotscom. They both.
Let me interrupt you on that point, and let me preface my first question, because my guess is there will be several with this theme. I know you weren't the trial counsel and you're stuck with the record, but from my reading of the record, there was not an offer of proof made as to what your client would have testified as to, and as you know, error alone in precluding evidence isn't sufficient. We have to have demonstrable prejudice, which has to be apparent from the record. Where can we find that?
I think we can find it in the fact that the appellee was the only party that testified as to value, and as it was argued by counsel at trial, that value, it was the opinion of appellant that value was low.
But how do we assess whether there would have been foundation for her testimony? I mean, what we know is she hadn't lived there for a couple of years. She lived in California. So we really, without an offer of proof, I'm not sure how we can grant relief on that issue.
I understand the court's concern with that about can we, even if we find there was error, can we clearly see whether there was prejudice to my client in this case. And again, I maintain that I think we can, that the only value the jury heard was the value from the other party, who maintained no damages were, one, there wasn't an agreement, and even if there was, no damages should be awarded because of other factors. And the jury's award was explicitly based on the value presented by the appellee. It took his value, subtracted the liens against the property, divided that in half, and that was the award. So I would maintain that it's clear that had appellant given a different value, potentially a higher value, on arguing that his value was far too low, that the jury's verdict would have been different but for the error. How much different is a question a jury would have to answer. But I challenge that it would have been different. We don't know if the jury would have believed her.
because we don't know the basis for her opinion. Again, without, and again, I hate to beat up on appellate counsel who weren't trial counsel because it's not your fault for the state of the record, but I think that's a big hurdle on that issue.
And if I may just add that there was argument or there was testimony provided and an argument offered based on a higher value and that was argued would have been more consistent with what my client would have testified to as to her opinion as to value, based on the fact that appellee refinanced part of the liens against the property essentially simultaneously with when my party was removed by forcible detainer from the property, when the relationship ended in this case. And from that made the legal argument that based on the value of the refinance, analyzing that under standard banking of 80% loan to value of the property, that based on what was lent by the lender, if that is 80% of what they believed the value was at that time in August of 2013, the value would have been nearly $50,000 higher than as testified to by appellee at trial. Because the loans and the way they were constructed resulted in $261,000 worth of loans against the property. If that's 80%, that would have put the value at around $325,000 as opposed to the $273,000 that the jury based their verdict on as the only opinion testimony before the jury. So, and again, I understand the court's concern regarding foundation and can we clearly show, is there enough on this record to definitively say whether there's prejudice? But the larger issue with this, I think, is that she was precluded from testifying when she should have been allowed to. Again, while I understand that without foundation even if this court would say that she should have been allowed to testify, is it reversible error because do we have clear prejudice from it? To an extent, I would say that on that point, the error elevated to the level that it was more than just an abuse of discretion, that it was a fundamental error in regards, because as the cases that I cited, the Gordy opinion and the Coventry opinion, it's clear that the rule is that equitable ownership does qualify as an owner. Again, but even an owner has to show that they have the knowledge necessary to do that. I mean, there is some discussion in some of the case law from this court that even an owner can be precluded from testifying if they can't show that they have the basis. And one of the things that comes to mind for me with that is this rule and most of how it's when it came about is from, it's long settled. It's been half a century that this has been the rule. When most people owned the property they lived on, that was about it. Now we have people owning property from all over. The basis that the courts have always said that the owner can testify is because they have a unique knowledge about the property. But modern times we have owners that live thousands of miles away that have never been on a property. They would be allowed to testify under the way the trial court interpreted the rule in this case. But a party that had more intimate knowledge but was only arguing equitable title would have been precluded. And I think that's an aspect of the law that maybe that was interpreted incorrectly by the court and needs to be clarified for the trial courts so that they understand that in addition to just whether they're an owner or whether they're not, that the court has to do some gatekeeping level as to whether, even if they have ownership status, whether they have the unique knowledge that is the historical root for the ownership exception to the expert testimony. The second issue we briefed in this case is whether the jury instructions in charge to the jury regarding conditional gifts or non-conditional gifts, whether the instructions given were error that require reversal for a redetermination regarding the nature of the ring in the engagement or commitment ring. It was referred to as both things, and that's one of the issues that I believe creates a problem with the jury instructions in this case, because the way the case was argued, the way that the court ultimately instructed the jury, it leaves the impression, or it seems that the one take from that for the jury clearly could have been, if you find it's an engagement ring, it was a conditional gift, which is not the law in Arizona.
Counsel, isn't your huge hurdle here the fact that there's no objection to this instruction that you're asserting is problematic? I mean, and if so, I mean, correct me if I'm wrong, but then our scope of review is what? Fundamental error, correct?
That's my argument, that this court can analyze this case under fundamental error to where...
What constitutional right is being implicated here? What constitutional right? Because we don't, in a civil case, we generally do not invoke fundamental error unless there's a substantial constitutional right at issue.
I get the only one that really would jump out would be is that it's equal protection, because the law was that the law wasn't that an engagement ring is a conditional gift, and the argument and the charge to the jury and the instructions, that's the way it was presented to the jury, that if you decide it was an engagement ring or even a commitment ring, if you believe it was given on the basis of the relationship continuing, by definition, it's a conditional gift. And that's not the law in Arizona. Arizona has maintained the standard. I don't know that it's ever clearly been delineated, but that a conditional gift, you have to look at the donative intent at the time the gift was given, and there has to have been clear, whether explicit or implicit, there has to have been clear, it has to have been clearly made known clearly that there was a condition on the gift. It can't just be from the specific circumstance. And if the jury was given the wrong information, and that's the basis that they decided the gift was that gift was conditional, whether fundamental or abuse of discretion, I understand the court's concern with whether it was objected to, and clearly, and to a certain extent, even in this case, it wasn't objected to. Both counsel actually agreed on the final instructions the court intended to give, but.
So,
the logical extension of your argument is any time a wrong jury instruction is given in a civil case, it's reversible error, which would be basically upending all appellate precedent. I mean, how could we go there?
I don't know that what I'm arguing goes there. What I'm arguing is that there was an error, even with the law in Arizona that isn't clear. There's never been a published opinion. There are several unpublished memorandum decisions that made it clear that in Arizona, this court notes that there's no clear distinction. It's just you have to do the factual determination. But there's no clear direction on it that where a jury is given an incorrect charge, and it's one where the court had the obligation to make sure the charge was correct, that creates the concern, the issue with whether it is reversible or should be reversible error or not, as opposed to. And I understand the court's concern in this case whether it's an error that will rise to the level that will benefit my client in this case, but I as well, again, this issue, much like the other issue, has the larger implications of future cases. I mean, I'm not saying that I acquiesce on the fact that I believe there is relief here for my client. I believe there should be, and the fact that the jury was instructed erroneously. It wasn't something left out. They were given incorrect instructions. They were left with instructions that told them if it was an engagement ring, it was conditional, and that's just not the rules here. And the way it was instructed, the way they were charged, the court essentially made that decision for them, and all they were left with was how much should the prevailing party be awarded in damages, because there was differing testimony from both parties as to the value of the ring, between an appraisal and what the ring was actually sold for, which was the more accurate. Ultimately, the jury decided that the damages would be what the ring was sold for. That was my presumption is that the jury determined that was a better indicator of the fair market value of the ring than an appraisal for insurance purposes. But on the issue of whether the court abuses discretion in awarding attorney's fees to the appellee, Mr. Weir, while the court's analysis of the different settlement adjustment tests from the case law from this court and the state Supreme Court regarding the standards in the second sentence of Section 341.01 regarding attorney's fees and contract. First, I mean the initial argument is that on all the contract claims, appellant prevailed. And the appellee went to great pains to argue there was no contract here, and the court pointed that out. And to the extent that the court analyzed all of those tests and ultimately awarded attorney's fees to appellee, the concern I have is that there's some language in the opinion or in the decision to award the attorney's fees that creates an appearance of and I'm not saying that the court was biased or that there was bias, but there's an appearance that there was based on the three sentences from that ruling that seem to say that it was the court's, that one interpretation of it anyway could be that the court thinks the jury got the case wrong and therefore awarded attorney's fees to correct that. And I don't know that that's something that would be that appearance of impropriety is something that I think is a legitimate issue in this case, and I did brief it in my brief. If Your Honors have no additional questions on any of the issues, I'd like to reserve the remainder of my time for rebuttal.
Okay, thank you.
Thank you, Your Honor. I am Eric Jackson. I represent the appellee, Eric Weir. I think that the court, it appears to me from the questions that have been asked, the court has read very carefully the briefs of the parties and the record. And so I'm going to go ahead and invite whatever questions the court may have, understanding that the court may want to zero in on particular issues, and I'd like the opportunity to respond to those. And if not,
if you could just briefly address counsel's last point about the allegation of bias by the Superior Court.
Well, first of all, during the course of this case, I filed a number of motions before the trial court which were denied. Those are not up on appeal. I thought the court was very well versed in this case, and I don't think there was any bias at all. Understand this: during the course of the case, there were 3 times where written offers of judgment were made, or offers of settlement were made. One was January the 27th, an offer of judgment for $50,000. Another offer of $55,000 in writing on February the 18th, 2015, and September the 2nd, 2015 for $60,000 confirmed in writing before the trial. What the court decided during the course of this trial was that given the attorney's fees that were incurred on behalf of Ms. Schledorn, the sum total of those fees that he determined he would allow, and it was his discretion to determine what the amount was, plus the net judgment, did not add up to the offers to settle.
Can
And
I zero in a little bit? I think more particularly perhaps on what Judge Brown is focusing on that Mr. Geiger raised at the end. It's the statements that Judge Gerlach made that throughout the parties' relationship, she benefited hugely from his generosity. As I read that comment, it is where he is evaluating the associated indemnity factor about whether it would cause extreme hardship to award fees. And he says, finally, the contention that an award of attorney's fees against Weir is appropriate because it would not cause extreme hardship to him does not warrant serious consideration. Then he explains that throughout the parties' relationship, she benefited hugely from his generosity. I think that's the alleged bias, and I
Right.
guess I'm seeing it more in the context of weighing the associated indemnity factors.
Well, yes. Basically, what he was saying is that she's not been prejudiced by incurring the fees in this case because she did receive a benefit. I don't know what the judge's thinking was there. I didn't ask him that question, but clearly, overall, the offers that were made exceeded the amount of the net judgment plus the fees that he allowed, and I think that's important. Something else that's important here. The judge did something very interesting. The last pleading that I filed in a reply, in the last sentence, I suggested, for the purposes of equity in this case, that the judge award fees in favor of my client, Mr. Weir, in an amount that equaled the net judgment. So that basically the parties, having bludgeoned each other through this litigation, would basically come out equitably. And that's what he did.
And the judge did significantly reduce the fee award over what your client had originally requested.
My client had requested $88,000, but in the last sentence of my reply, if the court will read that, I did suggest the result that he did order, and I think he did that to basically calm the waters and hope we wouldn't be here today, but to try to at the end make sure it was equitable. And I think that's what he did, and that's how I would respond to Mr. Geiger's statement that basically it was prejudicial, and it wasn't.
Any other questions? Okay.
Thank you, Your Honor.
Thank you, counsel. Mr. Geiger, anything further?
Yeah, just very briefly as to Judge Downey's question regarding or concern that she raised with Mr. Jackson regarding the language. It's the final three sentences of that paragraph from the minute entry that create the issue. And again, I'm not suggesting that there specifically wasn't any bias. It's just a reading of the final three sentences of that. Even understanding the context that Judge Downey is pointing out with the sentence prior to that, but those final three sentences of evidence at trial established convincingly that throughout the parties' relationship, Schledorn benefited hugely from Weir's generosity. Simply stated, the evidence established that this generosity allowed her to enjoy a lifestyle that she was not capable of providing for herself. To say that Weir should now pay Schledorn even more is neither fair nor realistic. A reading of that my initial impression when I read that is that he shouldn't have to pay her anything regardless of what this jury said. And that's where I say that there's a possible appearance. The rest of the analysis by Judge Gerlach is spot on. I mean, I took no issue with his analysis of the differing weighing tests and the net judgment and net settlement rule. He analyzed all those very reasonably, but that language creates an appearance that his ultimate decision whether to follow the recommendation of appellee's counsel, just award enough fees to just wash everything, and these two parties that have, as counsel put it, kind of bludgeoned each other over this several-year process and four-day trial, just both walk away equal at this point. I understand that point. However, especially that final sentence of that paragraph that says that he should have to pay her anything is just wrong. The jury disagreed. The jury found on the facts that were presented, even with the equalization and the fact that Mr. Weir prevailed on the ring and got some damages for that, that Ms. Schledorn should be compensated. And if that sentence leaves the air that the court awarded attorney's fees to negate the jury's verdict, which isn't the court's place. It's to award attorney's fees where it's equitable and proper based on the specifics, but not if the intent, which it seems it could have been. I'm not saying it was, that was the intent, but that is a reading of that sentence that it was done with that in mind. So that was the main point I had regarding that issue. Thank you.
Okay. Counsel, thank you both for your arguments. The court will take this matter under advisement. We will now take a brief recess to prepare the courtroom for the next argument. Thank you.